Welcome to AITV News. The Supreme Court has taken an unexpected step in a high-stakes voting rights fight out of Louisiana, leaving both the state's political map and the future of the Voting Rights Act in limbo. Instead of issuing a final ruling, the court announced on Friday, June 27, 2025, that it will rehear the case this fall, a classic judicial punt. In the next 4 minutes, we'll break down what the case is about and why the court's eventual decision could reshape elections nationwide. The story begins with the 2020 census. After the count, Louisiana's Republican-led legislature drew a new 6-seat congressional map. Although Black residents make up nearly 1/3 of the state's population, only one district had a Black majority electorate. A group of Black voters sued, saying the map unlawfully diluted their voting strength, something Section 2 of the Voting Rights Act forbids. A federal judge agreed and ordered lawmakers to draw a second majority Black district. Lawmakers complied, and that new district elected Democratic Representative Cleo Fields, flipping a formerly Republican seat. But almost immediately, another set of voters challenged the revised map as an unconstitutional racial gerrymander. Their argument: creating the new district relied too heavily on race, violating the Equal Protection Clause of the 14th Amendment. That clash puts Louisiana, and now the Supreme Court, in a legal catch-22. The Voting Rights Act demands states protect minority voting power. Constitution bars race from being the predominant factor in drawing lines. The contested district is hard to miss. Chief Justice John Roberts compared its 250-mile span from Shreveport down the Red River to Baton Rouge to a snake. State officials insist they were simply obeying the lower court and trying to preserve incumbents, not engineer a racial map. Why did the justices hit pause? The court offered no explanation, but analysts say the 9 may be deeply split on how to reconcile these two commands of federal law. Only Justice Clarence Thomas publicly dissented, writing that the court has an obligation to resolve what he called an intractable conflict. The delay lands amid a mixed record. This court has been skeptical of race-based policies, yet surprised many in 2023 by upholding Section 2 in a similar Alabama case. Practically speaking, the Snake District stays put for the 2026 elections, so Congressman Fields keeps his seat, for now. But the stakes extend far beyond one district. A ruling next term could redefine what remains of the Voting Rights Act, alter how every state balances race and representation, and even shift control of a closely divided U.S. House. That's where the Voting Rights Act stands after the Supreme Court's punt. We'll be watching when the justices return to the case this fall, and we'll keep you updated every step of the way.